Hi, my name's Collin Huerter. I'm a criminal defense attorney here with Roth Davies, LLC in Overland Park, Kansas. Today I'm going to be talking about restraining orders and what those look like in Overland Park and Johnson County. If a final order is entered following a hearing, that order is in effect immediately and it lasts for 1 year from that date. The terms from that order and its duration are then set unless one of three things happen. First, a party successfully appeals the final order to the Court of Appeals. Second, a party moves to modify the final order and the district court grants modification. Or third, within the timelines allowed by statute, a party files for an extension of the final order. First, let's talk about appeals. Appealing a final PFA or PFS order is an extremely difficult task. The trial court is given extreme deference in making its determination when issuing final orders of protection. Because of this deference, reversing the decision is virtually unheard of. Next, let's address modification. A final PFA order can be modified if a defendant can show there's a change in circumstances which justifies such a modification. Circumstances that could justify modification include completing any programs or reaching an agreement with the plaintiff to modify the terms. The court will hold a modification hearing, and at that hearing, if the party seeking modification carries the burden and successfully proves that, then the order can be modified. But modification is never guaranteed, and it's not very common. That's why it's imperative that during the initial PFA and PFS proceedings, you work to either fight the order or come to some sort of mutual agreement that's easier to live with and change if necessary. Finally, let's talk about extension of the final order. The order that's issued on the date of the final hearing will last for 1 year from that date. But further extensions can be granted, including a final extension of up to the lifetime of the defendant. In order to get an extension of the final order, the protected party must file a timely, certified motion with the court requesting the extension. Timely means you have to file the motion with the clerk of the district court prior to the end of the initial order. A copy of the motion must then be mailed to the defendant. The court may then grant an extension of 1 additional year if the court finds good cause and that an extension is reasonably necessary for the protection of the plaintiff. In other words, a court can give an extension of a year at its own discretion and not after a new finding of a preponderance of the evidence. A plaintiff can also file a timely and verified motion requesting an extension of 2 years or up to the lifetime of the defendant. In order to receive this longer extension, the timely and verified motion must be personally served on the defendant, and then the matter must be set for a hearing. At the hearing, the plaintiff must show one of the following. 1, the defendant violated the protective order. 2, the defendant has previously violated a protective order. Or 3, the defendant's been convicted of a person felony committed against the plaintiff or any member of the plaintiff's household. At the extension hearing, the defendant has the opportunity to present evidence and cross-examine the plaintiff's witnesses, just like at the initial hearing. But then it's in the judge's hands. Because this hearing could result in permanent, life-altering ramifications in your personal life and with your rights, it's imperative you contact an attorney immediately if you've been served with the papers for such a hearing. Even if we did not represent you in the initial hearing, we may be able to assist you in the extension hearing. Give us a call today for more information.